Divining Rod says 2 more weeks. Money Pit reference. No, it's not Money Pit reference. Although that is a funny movie with Tom Hanks. No, 2 more weeks is a reference to what Josh Moon kept telling everybody as far as when the body cam footage would be obtained. It's a reference to him saying he would definitely have the body cam footage in like 2 weeks and then 2 weeks and then 2 weeks and then 2 weeks. So kind of like, but it was kind of like COVID. Here we go. Speaking of great, this is from the Court of Appeals. This is filed today. This is filed today at, technically yesterday or whatever, at 4:19 p.m., so right before close of business. Based on the file record and proceedings, and because Josh Moon is fat, this appeal arises from an order following appellant Matthew D. Harden. This is Josh Moon's attorney, if you don't know. Following appellant Matthew D. Harden's motion to intervene in a criminal proceeding involving respondent Nicholas Robert Rekeita. That's me. Following a search of his home by law enforcement, Rekeita was charged by respondent state of Minnesota with second-degree controlled substance crime pursuant to Minnesota statute section 152.022 subdivision 2A1, which is possession of a substance greater than 25 grams that is not fentanyl. So cocaine primarily, a little bit of ketamine, and a little bit of whatchamacallit. Oh, it was cocaine, ketamine, and some MDMA that they recovered from a safe in my house. It was mine. I've pled guilty to it. It happened. It's a part of my life that is over and done with. But you know, it is real. Like it did happen, and I'm not going to shy away from talking about it. And I've admitted to my faults. Unlawful possession of a firearm or ammunition pursuant to Minnesota statutes, section 624.713, subdivision 110.3/2022, and a child endangerment child endangerment pursuant to Minnesota statute section 609.378, subdivision 1B2/2022. To be very clear, people confuse this and believe that this is related to a test on one of my children. It is not. The child endangerment charge was took place before the test took place. The child endangerment charge is because they found cocaine in a home where children were present. So they kind of default charge when that happens. With that said, that charge and the gun charge were dropped. Rekeita filed a motion to suppress evidence and dismiss the charges, arguing the search and seizure of his home was unlawful because the search warrant lacked probable cause. In support of his motion, he filed a memorandum of law that referenced the body-worn camera video of the 2 deputies who executed the search warrant at Rekeita's home. This is a weird sentence. Like, it doesn't matter. It should say 2 of the deputies. There were about 9, I believe. There are about 9 deputies, 9. There's 9 body cam files. Each one's about 2 hours long. It took a while to go through all of them. It wasn't really fun. It was interesting, though. 2 deputies who executed the search warrant at Rekeita's home. Additionally, in advance of the omnibus hearing, Rekeita uploaded multiple items into the Minnesota Digital Exhibit System, MINDES, including the 2 videos for potential use as exhibits at the hearing. In MINDES, the 2 body-worn camera videos are entitled Robbie Brannis and Quinn Pomplin. Those are the names of 2 of the detectives. Quinn Pomplin is the dork who was the lead investigator, who treated me like Scarface, which was kind of weird because I never like dealt drugs or anything like that, but all right. Okay, here we go. At the August 2024 omnibus hearing, the district court noted that Rekeita was requesting a Frank's evidentiary hearing. The district court then asked which of the items uploaded in MINDES would be offered as exhibits. Counsel for Rekeita responded that he was getting rid of the 2 BWC videos. And that's not the BWC you're thinking of. You just dirty sluts. Oh my God. I have way more than that. 2 BWC videos that were uploaded in the MINDES because the prosecutor had conceded the legal issue to which the videos related. A little backstory on this, without spending too much time. How do I word this? There was a 6th Amendment issue because they asked April, who was arrested at the time as well. They asked her some questions. She said she would not answer any questions without her attorney present. They said, okay. That was Robbie Brannis, who Mirandized her. She said she would like an attorney. Robbie Brannis then is asked to go inside, and Detective Quinn Pomplin takes over. This is within about a minute. Within about a minute of her invoking her right to counsel and to not answer further questions. Robbie Brannis tells Pomplin on the way, he says, hey, I Mirandized her. She said she won't talk without an attorney. Pomplin says, okay, walks up and immediately starts asking April questions. That's not legal. That's a violation of her Sixth Amendment rights that she had invoked. She's not to be interrogated. Now, it's different if you invoke your Fifth or Sixth Amendment right and you start speaking on your own. But the police officers at that time are not allowed to further interrogate you until you have an attorney present. They can't just keep asking you and wearing you down. He acknowledged that she was Mirandized. He acknowledged that she had invoked her Sixth Amendment right, and then he proceeded to ask her questions anyway. The answers to those questions were damaging to her. They were not damaging to my case. They were potentially they were damaging to her potential case at the time she made them. Well, none of us were charged yet. They were damaging to her potential case. I attempted to get them suppressed for a couple reasons. One, there were 3 criminal actions happening. There was mine, there was my wife's, and then there was April's. We were all charged. We all had open cases, and we had different schedules. There's a possibility that if there was a possibility of getting things taken out, we kind of had 3 shots at it because of that. Because we were all, we had subsequent cases. It was kind of like one person could take a shot, and then the next person, if they were unsuccessful. Was kind of how things were supposed to work out. It didn't really work out that way, but that was the idea. So I was the first one up with my omnibus hearing. Getting those statements removed would have eliminated her case entirely. So we took a shot at it. It didn't work. The judge basically said the issue wasn't ripe, and so we never had to talk about it. But to be very clear, the statements that she made just were statements that placed her in the home and made it easier for them to prosecute her. That's all. There's nothing super embarrassing. There's nothing whatever. She didn't like sing or talk to the cops like and tell them anything. She just basically admitted to being where they found an amount of cocaine. And because she admitted to being there in Minnesota, you're considered in possession if you're in the room and you know about it. So that's all that was. That was the whole thing. So just an attempt to get those statements thrown out under her Sixth Amendment rights. Basically, the prosecutor said she wasn't going to use them in my case, and so it mooted the issue. We didn't have to fight over it. During the remainder of the hearing, neither the district court nor the parties made any further reference to the BWC videos. Again, that's because the prosecutor and my attorney had said, "Hey, we don't need to deal with this issue at all. It's all taken care of." Chris Griffin says, is April still around? No, April has not been around for well over a year. She's, I guess, right around a year. But she has moved on with her life. And she had done that. When I say she was still around a year ago, she wasn't like around. She had already moved on with her life, and it was just the last time I had significant contact with her was about a year ago. And that was because briefly she was living at a property that I owned and I was selling it. So I had to make sure she got her stuff out so that I could get rid of it. Okay. Anyway, I try not to talk about her too much because she's not involved in any of this stuff or in anything at all anymore. Like, she's got her own life and doesn't need shit haunting her. Unfortunately, she's in this document just because she is. But that's it. Instead, the discussion turned to which items in Mindy's were being offered as exhibits in support of the motion. The transcript of the hearing reflects that the 2 BWC videos were not offered into evidence during the hearing. On September 24th, the district court issued its omnibus order denying Rekeita's motion to dismiss. The order lists the items that were offered into evidence by Rekeita as exhibits at the hearing. The BWC videos were not listed as having been offered or admitted into evidence in the district court's omnibus order. but the two BWC videos were mistakenly marked as admitted in Mindy's after the hearing. I'm not entirely convinced that this was mistaken, but I don't have any evidence other than other things that were similarly mistakenly done. But that being said, I'll take the court's word for it. I don't have any evidence to the contrary at present. Here we go. On April 22nd, 2025, Hardin is Joshua Moon's attorney. Hardin requested access to the BWC videos by submitting a Minnesota Judicial Branch request form. The district court initially granted Hardin's request to access the BWC videos, provided he viewed them at the Candioi County Courthouse, but revoked access on May 30th after the state filed a motion to correct court records in the case to properly reflect that the two body camera videos were never offered or received as exhibits at the omnibus hearing. This was amazing because this was very clever. This was a workaround. They filed this document based on an accident that I don't really understand how they knew about this accident happening, but they filed this request form in relation to the accidental filing, and I wasn't included in it. They didn't have to serve me, apparently, even though, there are lots of people's rights who are implicated in that video. They were not allowed, or, none of those people, self included, and some people who are not in my immediate family and as well, they were not allowed to respond. They were not allowed to protect their own privacy or rights, which is a little crazy to know that is a thing that can happen.
It sounds like the baldo of justice has fully penetrated the prison purse of Mr. Moon, leaving behind a gaping, blown-out hole yearning to be filled again. He should have pleaded the fifth, micro-peen.
Yes. Some people have said some really inappropriate stuff about my children, about my wife, and that will, you can say it wherever you want, right? But just not in my house. But if you're relatively, civil towards other people, you can be shitty towards me all day. I don't care. Go for it. Get it off your chest. Get it off your tits. Let's see. So here we go. In a May 30th order, the district court noted that both parties agree and clarify that their intent was not to offer or have the body camera footage marked in Mindy's as received. The district court further specified that it did not rely on the body-worn camera videos in its decision on the omnibus issues. Accordingly, the district court amended the Mindy's record to mark the two body camera videos as accepted, or as not accepted. There we go. Hardin filed a motion to intervene in Rekeita's criminal proceeding as of right under Minnesota Rules of Civil Procedure 24.01 for purposes of seeking to vacate the district court's May 30th order and to assert a right of access to the BWC videos. In a written order, the district court granted the motion to intervene, but denied Hardin's request for access to the BWC videos. In deciding to grant intervention, the district court recognized that Hardin erroneously relied on the Minnesota Rules of Civil Procedure to assert a right of intervention in this criminal case and noted that the Minnesota Rules of Criminal Procedure govern the case. This was really weird. So Hardin did move to intervene in my criminal case, and intervention in a criminal case doesn't make sense. That means that you have rights that are impacted by what happens to the defendant in this case. And I'm sorry, but you don't have a right to intervene on the criminal liability. And if you think about it, that wouldn't make sense, because you could have someone literally come in and shield the other person from criminal liability. And that's not how things work. We don't get to do that. But other jurisdictions have allowed intervention in criminal proceedings for the limited purposes of retrieving documents. However, let's just put it out there. All of the citations to this involve documents that were not given to the defendant themselves. So not only were they asserting the right of public access, the defendant didn't have access to the documents. Typically, they're classified documents in the cases that were cited, including Abrego Garcia, the recent United States export to El Salvador. But getting back to it, he attempted to intervene. The district court granted a limited intervention. But here we go. The district court also noted the criminal rules contain no express provision for third-party intervention for this purpose, but the district court went on to conclude that despite the lack of directly applicable Minnesota authority, the district court retains discretion to allow limited intervention solely to determine access rights, provided that no disruption occurs to the underlying criminal process. The district court further concluded that Hardin has no right to access the BWC videos requested because the footage from the body-worn cameras in question was not formally offered or admitted and therefore remains outside the scope of public access. The district court also decided that no further briefing or hearing on this limited intervention is required. Hardin appeals. I don't know to who. Hardin, you meanie. I actually like Hardin. I actually like him. I like Hardin. Joshua Moon has Hardin as an attorney because of me. That's why Hardin is his attorney, and I like the guy. I don't think he thought through this case very well, and I mean he's doing what his client asked, so I guess that makes it good. But hey, Hardin, ha! I know he didn't actually. He acted as a straw petitioner, though. Hardin didn't argue the case. This guy named Oliver Bromke did. And that guy's a dork. That guy is not good at what he was allegedly doing. But Hardin may have done better on his own, but Josh was too busy trying to hide behind him for some reason. Like, I don't know why Josh didn't just say he was wanting to do it. But here we go. Hardin argues that the district court erred when it concluded that he is not entitled to access the BWC videos. Alternatively, he contends at a minimum that the district court should have held a hearing before denying his request. The state contends that Hardin has no right to intervene in a criminal case for the purposes of seeking access to the BWC videos. Both respondents also argue that the district court properly concluded that Hardin does not have a right to access the BWC videos. Both respondents is kind of confusing. They mean me and the county. Me and the state, me and the county, whatever. But both respondents is not both parties. There are two respondents. There's the county, there's me. And then the petitioner would be Hardin. All right. Whether intervention is available to Hardin is a criminal case. In this criminal case, presents a legal question that we review de novo, meaning they review the whole file. Let's see. Addressing procedures applicable to enforcing settlement agreement. So these are just citations to this. I'm not going to read all of them. The Minnesota Supreme Court has adopted procedural rules governing both civil and criminal cases. The Minnesota Rules of Civil Procedure allow for intervention in civil cases under specified circumstances, but the Minnesota Rules of Criminal Procedure do not include any rule that allows for intervention in a criminal case. See Minnesota Rule of Civil Procedure 24.01-.03, allowing for intervention but applying only to civil proceedings. Minnesota Rule of Criminal Procedure 25.01, addressing the process for excluding the public from certain pretrial proceedings but not directly establishing the process for intervention. See also Minnesota Rule of Civil Procedure 1, explaining that the scope of the rules of civil procedure is limited to civil suits. Minnesota Criminal Procedure 1.01, explaining the rules of criminal procedure govern the procedure in prosecutions for felonies, gross misdemeanors, misdemeanors, and petty misdemeanors. Nor is there any binding case law recognizing a right to intervene in a criminal case, even for the limited purpose of seeking access to court records. Put another way, there is no Minnesota court rule or precedent allowing or providing for intervention by a third party in a criminal proceeding to pursue a civil remedy, as Hardin requests here. The district court recognized as much in its order, but it still allowed intervention for the limited purpose of determining access rights to the BWC videos. Because there is no authority permitting intervention in a criminal case in Minnesota district court, even for this limited purpose, we conclude that the district court erred when it granted Hardin's motion to intervene in this criminal proceeding. Oh my goodness, it's very, very upsetting. Very, very upsetting that they erred in that. Our conclusion is reinforced by the constitutional protections afforded to a defendant in a criminal case. Both the federal and Minnesota constitutions protect a criminal defendant's right to a speedy trial. U.S. Constitutional Amendment 6, Minnesota Constitutional Article 1, Section 6. Allowing intervention by a third party in a criminal case for the purposes of determining whether the third party should be permitted access to court records could disrupt or delay the criminal proceeding, potentially interfering with the defendant's right to a speedy trial. This constitutional consideration strengthens our conclusion that there is no right for a third party to intervene in a criminal case in a Minnesota state court to seek access to court records. Again, all of the cases that they cited around this had a very had a key linking component, and that was that the defendant did not have access to the documents either. Because if there's a right of public access, it's because the defendant has the right to release it. They just do. Like that creates, this accessibility to the public. The defendant can do it. If the defendant can't have access to their own documents, the public can't have access to them either. There's no way to get them at all. So the right of public access is created to stop courts from doing that. Or not created, I guess it was recognized. To stop courts from doing that, from not allowing the government to mark a document as secret or classified or whatever, and withhold that from the public and withhold it from the defendant. In my case, nothing was withheld from me, and nothing was withheld from the public that would have been made public. Everything was available. Everything is open. There's nothing that's sealed or locked away at all. There is in my family case, that's a whole different thing. But in the criminal case, everything was available to the public. Everything still is. You can go download the documents that were used in the case. That's what's out there. You can't get access to the other stuff, because it wasn't used. So much of that stuff is private info. Some of it will maybe eventually become public. It's hard to say. Let's see. K to the Swiss says Nick wins. Yeah, and thoroughly and in an unclean manner, to be honest. Sounds like Nick and his wife did coke and she blamed him for everything. She didn't blame me for anything. What are you talking about? The question is not who did coke. Like, that's not the legal question in Minnesota. The question in Minnesota is about possession at the time. At the time of the arrest, it was mine. It was in my locked safe that I had the combination to, and neither of the other people in the house did. So it was mine. I pled guilty to it because it was. There's no way around it other than that. They were going to probably win that case. So you go ahead and negotiate out the terms is what I would recommend. Let's see, at oral argument. And in a letter that Hardin filed shortly after oral argument, Hardin directed this court to authority from other jurisdictions that have permitted third parties to intervene in criminal cases for the limited purposes of asserting the right of access to court documents. We decline his invitation to follow these non-binding decisions for the reasons set forth above. Imholte versus Minnesota Gas Company just stands for the notion that noting that decisions from foreign jurisdictions are not binding. On January 26, 2026, this is just a couple days ago, Hardin filed another letter with citation to additional supplemental authorities. This letter was not promptly filed and includes argument. We therefore decline to consider it. See Minnesota Rule of Civil Appellate Procedure 128.05, providing that a party may promptly file a letter setting forth the citations to supplemental authorities without argument. Emphasis added. And contrary to Hardin's suggestions, our conclusion does not leave Hardin without a vehicle to challenge purported violations of his First Amendment rights, resulting from the district court's order denying access. The Minnesota Judicial Branch has rules governing public access to its records, and those rules provide a mechanism for requesting access. Under Rule 7, a person may request copies of judicial records that are accessible to the public. Minnesota Rule of Public Access to Records of Judicial Branch 7, Subdivision 1. If the request is denied, Rule 9 provides that the person may appeal the denial to the state court administrator, who shall promptly make a determination. Minnesota Rules of Public Access to Records of Judicial Branch 9. There's a rule book for everything. Additionally, persons who have been denied access to court records by a district court order have challenged such decisions by petitioning for a writ. In Camere, for instance, a newspaper company petitioned the Minnesota Supreme Court for a writ of mandamus to require the district court to release all closed documents in a criminal case. Minneapolis Star Tribune versus Camere. Similarly, in Anderson, two newspaper companies sought relief from the Supreme Court in the form of a writ of prohibition that would restrain two district courts from enforcing their respective orders, which prevented public access to documents relating to two pending criminal prosecutions. Northwest Publications, Inc. versus Anderson. Aggrieved parties may use these processes. They would lose dramatically on these, by the way. Aggrieved parties may use these processes to vindicate their rights without infringing on a defendant's constitutional right to a speedy trial through unnecessary delay and proceedings. And this really did infringe on my right to my my right to a speedy trial, I guess. I pled out, right? But upon that plea, everything should be roughly finalized. It should be done. But it wasn't because of the intervention. I was then forced to go through and defend this. Like I was to fight for my own privacy, which is guaranteed to me by any reading of the law and every reading of the law. Criminal defendants have the right to a speedy trial under the constitutions of both United States and Minnesota. We therefore conclude that Hardin did not have a right to intervene in this criminal case to seek access to the BWC video. This conclusion, this is where it starts to get a little bit juicy, in my opinion, right here at the end. This conclusion is a sufficient reason by itself to affirm the district court. We may affirm the district court on any ground, including one not relied on by the district court. But they don't. They take the time, because they could have just denied it on this and said, we're good, fam. Get out of here. Too bad. They take the time to let him know that he was wrong, like completely incorrect. They take the extra time to write this out, and we're almost done with this. I know this is personal, and so I know it's not as it's not as universally interesting to everyone, but we're almost done with this. There's only a page left. Even assuming Hardin had a right to intervene, which he did not, the district court properly denied Hardin access to the BWC videos. A recent order of the Minnesota Supreme Court provides exhibits uploaded and stored in Mindy's but not offered to the court. Those exhibits in pre-hearing status are not case records of the Minnesota Judicial Branch as defined in the rules of public access and are not publicly accessible. Now, any lawyer in Minnesota on this issue should fucking know this. It doesn't take long to find out. Hardin is licensed in Minnesota, and so is Bromke. Both of them must have, unless they didn't do their jobs, must have known that they were going to lose on this case. They must have known from the start, which means they must have told Josh, which means that Josh lied to his little community for the purposes of extracting money from them, promising them something that he was not going to get. And any read of this law says that they were not going to get it. They were throwing a Hail Mary, hoping to God for a retarded judge. Like that was their only hope. The actual type of lawyering everyone hates is what they did. But if they did their job as attorneys, both Bromke and Hardin would have told Josh Moon, you will not win this. You will not win this. There's no way. And I would assume they did, which means that Josh intentionally lied to his audience for the purposes of stealing money, which just kind of reflects who Josh is: fat and lazy. So this is from the order regarding the use of Minnesota Digital Exhibit System in Minnesota District and Appellate Courts. Here, the record reflects that the BWC videos were never offered into evidence, as the district court found. Rekeita's counsel uploaded BWC videos in question to Mindy's before the omnibus hearing, as he was required by law to do, by the way. But his counsel decided to get rid of those two exhibits and never offered them at the hearing. The transcript of the hearing confirms this finding by the district court. The clerical error marking the videos as admitted in Mindy's does not make them publicly accessible. It is the fact that a document is offered to the court that converts such file into a publicly accessible document. Here, the record is clear that no such offering or acceptance took place. Because the BWC videos were not offered into evidence, the Mindy's order directs that the videos are not case records and are not publicly accessible. Therefore, the district court correctly concluded that the videos are not court records and are not accessible through an MJB records request. So this is what they mentioned earlier that had been done. They cannot win on this issue. They lose. They lose. Hardin also argues that the district court abused its discretion by not holding an evidentiary hearing on his records request. But because we conclude that Hardin has no right to intervene in Rekeita's criminal case, he has no right to a hearing and any error he may assert is harmless. See Minnesota Rules of Civil Procedure 61, stating that this court must disregard any error or defect in the proceeding which does not affect the substantial rights of the parties. Minnesota Rules of Criminal Procedure 31.01, any error that does not affect substantial rights must be disregarded. We therefore discern no abuse of discretion on the part of the district court in denying Hardin's request for a hearing. It is hereby ordered. The district court's order is affirmed. Pursuant to Minnesota Rules Civil Appellate Procedure 136.01, Subdivision 1C. This is where I lose. This is the one place where I lose. It makes me sad. This order opinion is non-precedental, except as law of the case, res judicata, or collateral estoppel. So, unfortunately, we're not making Minnesota law here. Unfortunately, we're not making new law. We will not be recorded in the Northwest Reporter. But that's okay. That's all right. I'll just take the fucking victory. Wait a minute. I believe that Josh Moon made a wager with Ethan Ralph. I believe they wagered $5,000. Hey, Josh, you owe Ralph $5,000. You going to pay up? You going to pay up, or are you going to be a whiny bitch about it? I have a feeling I know which one it's going to be. If you not only lose to me through this, but you also lose to Ralph, how did you fuck up that hard? Hey, Josh, maybe it's time for a pulse check on your sanity. You are not the internet's god. You're fat. You can't do a push-up. You can't interact socially in person without sweating. The smell of you must be absolutely repulsive. Maybe go back to doing what you actually were good at for a while. You actually, for a while, were defending speech. You're archiving the internet. And you didn't get so fucking emotional, you woman. Those soft ass eyes. That's what started all this. It's so funny. You're so sensitive about how I tricked Drexel into making fun of your dumb face. It was all in good fun, brother. It was all in good fun. I actually felt bad about it because it was completely a joke. But that's what started it, because you're petty and insecure. You're a big, fat baby with the emotions of a mentally unstable, middle-aged woman. And it's really embarrassing, buddy. And that's coming from me. I destroyed my whole life really, really well. Really thoroughly for a little while. And you're embarrassing to me. It's kind of pathetic. I mean, it's really pathetic. It's not kind of. It's pretty bad. It's pretty bad. K to the Swiss says, Nick, come on now. Are you going to tell me you wouldn't take money from a loony troon for a frivolous lawsuit? Look, I hope he pays up to Ethan Ralph. Ralph, if you need a copy of the order or anything, just let me know. I'll happily send it over if you want to have people check the wager records. You lost. Ah! You idiot. Again, at least Josh didn't give his kids Coke, Nick. I didn't either. You weirdo. But Josh doesn't and won't ever have kids because Josh has problems when it doesn't involve looking at Shota porn, according to Josh. So I don't suspect we'll ever see Josh tested on the children aspect. Also, there is a God, and I think he does have a hand in some stuff. Anyway, that's that. That's my personal issue. Try to keep it down to a shorter amount of time, you know. I'm not going to get over it for a while. I will be pursuing fees on it though, because it was an obviously frivolous lawsuit. There was no legal path to victory. There's no fact that could have brought a path to victory, and any elementary reading of the law by any licensed attorney in Minnesota would have said the same thing. And someone may have boasted that they were just doing this to try and cost me money. I do not expect to win on the fees just because of how that works in Minnesota. But, you know, doesn't hurt a girl for trying. I had to, you know, my lawyer had to spend a lot of time fighting this stupid, frivolous action. All because of one fat weirdo's obsession with seeing someone's kids. Gross. Heisenberg 2A says that's awful that he dragged it out. You should sue him and own his little website. I don't want to sue anybody. That's the thing. I don't want to sue anybody or do anything. I want to, you know, like do my show, hopefully bring some entertainment to people out there, and a little bit of legal education from time to time. And, you know, tell stories and learn the stories of other people. That's what I want to do. That's it. Simple man, simple stuff. I don't have giant aspirations to like, intervene in the lives of anybody or interfere. I just, you know, I might make fun of someone from time to time or whatever, but once I'm done making fun of their circumstance, it's over. Who cares? Like the joke's done and we move on. And they move on. And what do you do? I hate when drama interferes with life. I hate when drama goes like too far or whatever. Do I hate like people talking about, you know, like what happened or whatever? No, not really. Like, what do you do? What do you do about that? Holly Movie Star says, what was wondering, basic law, no specifics. Yeah. I mean, you need specifics to make that determination. But I mean, if you're going to plead guilty and you can get a no contest plea or an Outford plea, like do that. always maximize the amount of things you can maximize, like your advantages and protections. Again, if you can not admit to the facts of the case and just admit that the state will present a case that finds you guilty, okay, good. Then you haven't admitted to facts that might be, like, even in a way you don't foresee now, might become, you know, very problematic in the future. So mine, there was no way around it. You know, I had to plea and admit to the facts of my case. Like, but what was I going to do? Like I'd made public statements. Well, no, I hadn't made public statements yet, but I was going to talk about it. It was going to be asked of me every single day until I said something. So I wasn't going to try and, claim no knowledge of the facts and then go out on a live stream and be like, oh yeah, so here's what happened. Like that wasn't going to work. That wasn't going to work at all. But we didn't need to do that. The statute actually will protect all of it anyway. The statute that governed my plea basically allows the case to be sealed, and I'm not actually convicted of any crime. I'm on a probationary period that happened at sentencing, but I'm not convicted. I'm not a felon. I don't lose my rights. I don't lose my right to vote. I temporarily cannot own guns, but I don't lose my gun rights. A big difference there. When my probation is over, I will be able to own a handgun or rifle or whatever again, just fine. So, you know, those were the critical things of my plea. I didn't really care about admitting to the facts or not of owning